You smoke marijuana legally in Colorado. You have a medical card. You use it for chronic pain. But under federal law, you're a prohibited person. You cannot own a gun. You cannot buy a gun. If you lie on Form 4473 and say you're not a marijuana user, that's a federal felony. 5 years in prison. And if you own guns while using marijuana, even in a legal state, that's possession of a firearm by a prohibited person. Another federal felony, 10 years in prison. This is the marijuana gun ban. And it affects millions of Americans in states where weed is legal. But the federal courts are now split on whether this ban is constitutional. The Fifth Circuit just upheld the ban. But other circuits have struck it down. And that split means one thing: the Supreme Court is going to have to decide. And depending on how they rule, millions of gun owners in legal marijuana states could either keep their rights or lose them forever. This is the next major Second Amendment battle. And it's happening right now. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal affects anyone who uses marijuana and owns guns, and that's millions of people in states where weed is legal. The circuit courts are giving conflicting rulings. And when the Supreme Court takes this case, the decision will determine whether you can keep your guns or become a felon. Hit that subscribe button right now so you never miss updates on this case. Here's what's happening and why it matters. Federal law says if you're an unlawful user of a controlled substance, you cannot possess firearms. The law is 18 U.S.C. section 922G, which is 3. It's part of the Gun Control Act, and it's been on the books since 1968. The law says anyone who is an unlawful user of or addicted to any controlled substance is prohibited from possessing firearms. Marijuana is a Schedule I controlled substance under federal law. That means even if your state legalized it, it's still illegal federally. So if you use marijuana, you're an unlawful user of a controlled substance under federal law, and that makes you a prohibited person. You cannot buy, own, or possess guns. When you go to buy a gun, you fill out ATF Form 4473. Question 21E asks, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? If you use marijuana, the truthful answer is yes. And if you answer yes, the dealer cannot sell you the gun. But if you answer no and you're lying, that's a federal crime. Making a false statement on a Form 4473 is a felony punishable by up to 5 years in prison. And if you buy the gun and possess it while using marijuana, that's another felony. Possession of a firearm by a prohibited person under 18 U.S.C. section 922G gets 3, up to 10 years in prison. This law has been enforced for decades, but it's always been controversial, especially as more states legalize marijuana. Right now, marijuana is legal for recreational use in 24 states. It's legal for medical use in 38 states. That means tens of millions of Americans legally use marijuana under state law, but under federal law, they're all prohibited from owning guns. For years, gun rights groups and civil liberties groups have been challenging this law, and after the Supreme Court's decision in Bruin, those challenges started succeeding. Because Bruin said gun regulations must have historical analogs. If there's no tradition of disarming people for a certain reason, the law is unconstitutional, and there's no historical tradition of disarming people because they use substances. Yes, there are historical laws against public drunkenness or being intoxicated while carrying a gun, but those are different. Those are about being impaired in the moment. The federal marijuana ban is different. It says if you use marijuana at all, even occasionally, even in the privacy of your home, you lose your gun rights permanently. There's no historical analog for that. So courts started striking down the law. In 2023, the Fifth Circuit struck down the marijuana gun ban in a case called United States versus Daniels. The court said the ban violates the Second Amendment. Now, there's no historical tradition of disarming sober people just because they use substances when not carrying guns. But then in 2024, a different panel of the Fifth Circuit reached the opposite conclusion in a different case. They upheld the ban. And in 2025, the Fifth Circuit sitting on bank, meeting all the judges together, reversed Daniels and upheld the ban. The court said the government has an interest in keeping guns away from people who use impairing substances. Other circuits have split. The Ninth Circuit struck down the ban in a case involving a medical marijuana user in Nevada. The Sixth Circuit upheld the ban. The Tenth Circuit is considering a challenge right now. We have a circuit split. Different courts are giving different answers to the same question. And that's exactly the situation that gets the Supreme Court's attention. When circuits disagree, the Supreme Court steps in to resolve the split. So the question is not if the Supreme Court will take a marijuana gun ban case. The question is when. And the answer is probably soon. Maybe as early as the October 2026 term. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down which states' gun owners are most at risk under the marijuana ban and how enforcement actually works. Subscribe right now so you don't miss it. Now let's talk about the arguments on both sides. Because this is a genuinely difficult constitutional question. The government's argument is straightforward. Marijuana impairs judgment and motor skills. People who use marijuana are more likely to make bad decisions. Letting them have guns creates a public safety risk. Historically, governments have always had the power to disarm people who are dangerous. Substance abusers are dangerous. Therefore, the marijuana gun ban has a historical foundation. The gun rights argument is also straightforward. The Second Amendment protects the right to keep and bear arms. You can't strip someone of their rights just because they use a substance, especially when that use is legal under state law and occurs in private. The historical laws the government cites are about public intoxication and carrying while drunk. Those are about being impaired in the moment. The marijuana ban is different. It disarms people permanently based on private conduct that doesn't involve guns. And here's the key point. Under Bruin, the government has to show a historical tradition. But there's no tradition of permanently disarming people for substance use. Yes, you could be arrested for public drunkenness, but you didn't lose your gun rights forever. The marijuana ban is broader and harsher than any historical law, so it fails the Bruin test. Now there's a third argument. It's coming from an unusual source, the ACLU. The American Civil Liberties Union has teamed up with the NRA to challenge the marijuana gun ban. This is a strange alliance. The ACLU is usually on the opposite side of gun rights cases, but they care about civil liberties, and they see the marijuana ban as a violation of due process. The argument is this: you can't strip someone of a constitutional right without due process. The marijuana ban does exactly that. It strips gun rights based on self-reported drug use. There's no hearing, no chance to defend yourself, no finding by a court that you're dangerous. You just check a box on a form and you lose your rights. That's unconstitutional. The ACLU also argues the ban is unconstitutionally vague. What does unlawful user mean? If you smoked weed once 6 months ago, are you a user? If you have a prescription but haven't used it in weeks, are you a user? The law doesn't say. The ATF issued guidance saying they consider someone a current user if they've used marijuana recently or regularly. But recently and regularly are undefined. So people have no clear notice of when they're breaking the law. That's a due process violation. Now, quick legal note. This is educational information, not legal advice. If you use marijuana and own guns, you are currently violating federal law. The marijuana gun ban is still in effect. Courts are split, but the law hasn't been struck down nationwide. If you're prosecuted, you could go to prison. Consult with an attorney about your specific situation. Do not rely on this video to make legal decisions. Let me give you real-world examples of how this plays out. Imagine a guy named Steve. Steve lives in Colorado. He has a medical marijuana card. He uses cannabis to treat PTSD from his military service. He also owns guns. He's had them for years. Bought them before he started using marijuana. Steve is technically violating federal law right now. He's a prohibited person in possession of firearms. If the ATF finds out, they could prosecute him. How would they find out? Maybe Steve posts on social media about his use and his guns. Maybe a disgruntled ex calls the ATF and reports him. Maybe Steve gets pulled over and a cop sees his medical card and his gun in the car. Any of those could trigger a federal investigation. Steve could be charged with possession of a firearm by a prohibited person. He could face 10 years in prison. And it doesn't matter, that is legal in Colorado. Federal law controls. Now imagine a different scenario. Imagine a woman named Lisa. Lisa lives in California. She doesn't use marijuana, but she goes to a gun shop to buy a pistol. She fills out Form 4473. Question 21E asks about use. Lisa has never used marijuana, but she's nervous about the question. She's heard stories about people getting prosecuted. She's worried if she answers wrong, she'll get in trouble. So she hesitates. The dealer sees her hesitation. He asks, "Is there a problem?" Lisa says, "I'm just not sure how to answer this. I don't use but I've been around people who do. Does that count?" The dealer says, "If you're not a user, answer no." Lisa answers no. She passes the background check. She buys the gun. Lisa did nothing wrong. But the vague wording of the question created unnecessary stress and confusion. That's the problem with the law. It's unclear. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about enforcement. How does the ATF actually enforce the marijuana gun ban? In most cases, they don't. The ATF doesn't have the resources to go after every marijuana user who owns guns. There are millions of them. So enforcement is selective. The ATF targets people who come to their attention for other reasons. Maybe you're involved in a crime. Maybe someone reports you. Maybe you're under investigation for something else and they discover you use and own guns. Then they add the marijuana gun charge. It's a stacking charge. It increases your sentence. But if you're just a regular person who uses marijuana legally in your state and owns guns for self-defense, the odds of the ATF targeting you are low. That doesn't mean you're safe. It just means you're unlikely to be prosecuted unless you do something to draw attention. Now let's talk about the circuit split in detail, because it matters for where you live. The Fifth Circuit, which covers Texas, Louisiana, and Mississippi, has upheld the marijuana gun ban. If you live in one of those states and you use marijuana and own guns, you're at higher risk. The Fifth Circuit's ruling gives the government a green light to prosecute you. The Ninth Circuit, which covers California, Oregon, Washington, Arizona, Nevada, and others, struck down the ban in one case, but the issue is still being litigated. So the law is in flux in the Ninth Circuit. The Sixth Circuit, which covers Michigan, Ohio, Kentucky, and Tennessee, upheld the ban. The Tenth Circuit, which covers Colorado, is considering a challenge. We're waiting for a ruling. Other circuits haven't ruled yet. So depending on where you live, the legal landscape is different. But here's the thing. Even in circuits that struck down the ban, the federal law is still on the books. The ATF can still enforce it. You're still taking a risk. Let me give you another scenario. Imagine a guy named Tom. Tom lives in Michigan. Michigan legalized recreational. Tom uses it occasionally. He also owns guns. Tom hears that some courts have struck down the gun ban. He thinks, great, I'm safe. Wrong. Tom is in the Sixth Circuit. The Sixth Circuit upheld the ban, so Tom is not protected. If the ATF prosecutes him, the Sixth Circuit will side with the government. Tom is at risk. He needs to either stop using or get rid of his guns. Keeping both is a federal felony. Now let's talk about what happens when this case reaches the Supreme Court. The court will have to decide whether the marijuana gun ban violates the Second Amendment. Based on the court's recent gun rights decisions, especially Bruin and Rahimi, here's my prediction. The court will strike down the ban, at least in part. The court will say you can't permanently disarm someone just because they use, especially in states where it's legal. But the court might allow narrow restrictions. For example, the government could prohibit carrying a gun while actively intoxicated, or they could require a waiting period or a sobriety test before buying a gun. But a blanket lifetime ban based on past use, that won't survive. The dissent will argue that marijuana impairs judgment and the government has a compelling interest in keeping guns away from drug users. But the majority will say the ban is too broad. It sweeps in too many people who pose no danger, and it lacks historical foundation. That's my prediction. But we won't know until the court rules, and that could be years away. This information could literally determine whether you keep your guns or lose them if you use marijuana in a legal state. Subscribe now, because my next video breaks down the exact text of 18 U.S.C. 922G3 and the ATF's interpretation of unlawful user. Hit that subscribe button. Now let's talk about what marijuana users who own guns should do right now. Option 1, stop using. If you stop, you're no longer an unlawful user. After a reasonable period of time, maybe 6 months to a year, you can honestly answer no on Form 4473. You can buy guns, you can keep the guns you have. This is the safest legal option. Option 2, get rid of your guns. If you want to keep using marijuana, transfer your guns to someone else. Sell them, give them to a family member, store them with a friend. As long as you don't possess them, you're not violating Option 3, move your guns out of state. If you live in a legal marijuana state, but you have family in another state, you could store your guns there. You're not possessing them in your home state where you use marijuana. This is a gray area legally, but it reduces your risk. Option 4, take the risk. Keep using and keep your guns. Understand you're violating federal law. If you're prosecuted, you have no defense under current law. You're gambling that the ATF won't target you and that the Supreme Court will eventually strike down the ban. This is the riskiest option. And Option 5, challenge the law. If you're willing to be a test case, contact gun rights organizations. They're looking for plaintiffs. You could be the person who takes this issue to the Supreme Court. But be prepared. You might face prosecution, you'll need a good lawyer, and the process takes years. Now let's talk about the timeline for the Supreme Court case. The circuit split exists now. Gun rights groups will petition the Supreme Court for certiorari, asking the court to take the case. The court decides which cases to hear in the fall for the next term. So a petition filed in 2026 could be considered for the October 2026 term. If the court grants cert, oral arguments happen in late 2026 or early 2027. A decision comes down in June 2027. That's the optimistic timeline. But it could take longer. The court might wait for more circuits to weigh in. They might wait for the issue to percolate. We could be looking at 2028 or 2029 before we get a final ruling. In the meantime, the law is in effect, and people are at risk. Look, I spend hours every week tracking circuit splits, reading court opinions, and predicting which cases will reach the Supreme Court so you know what's coming. The least you can do is subscribe to make sure you never miss the update when the court finally takes this case. Subscribe right now. And if you found this helpful, share it with every gun owner you know who uses marijuana in a legal state. They need to understand the risk they're taking and the legal battle that's coming. Spread the word. Remember, this is educational information based on current circuit court decisions and federal law. It is not legal advice for your specific situation. The marijuana gun ban is still federal law. If you use and possess guns, you are violating that law. The penalties are severe. Consult with a firearms attorney and a criminal defense attorney before making decisions. Stay informed, understand the risks, and watch this space. Because when the Supreme Court rules on the marijuana gun ban, it will affect millions of Americans. And depending on how they rule, you'll either keep your rights or lose them. This is the next major Second Amendment battle. And it's just getting started.